Get ready for the dictation. Start. I have considered the submissions of learned counsel for the parties and perused the record. The opposite party number 1, Sri Rizwan Nabi Siddiqui, was employed as conductor on temporary basis in the petitioner's corporation. He was placed under suspension by means of the order dated 19/3/2004 and a charge sheet was served requiring him to submit the explanation/reply. Assistant Regional Manager Finance Gorakhpur was appointed as inquiry officer. The opposite party number 1 had submitted his reply on 1/5/2004 in which he denied all the charges and submitted that the charges have been leveled against him with malified intention. Thereafter, an inquiry was conducted, on the basis of which the opposite party number 1 was removed from service by means of the order dated 27/10/2006. The opposite party number 1 had filed an appeal which was dismissed by means of the order dated 17/4/2007. Thereafter, he preferred a representation on 16/8/2007 to the Chief Manager, Headquarters, Lucknow, which was dismissed by means of the order dated 2/4/2009. Thereafter, the opposite party number 1 preferred a writ petition number 49049 of 2009, which was dismissed by means of the order dated 28/7/2010 on the ground of availability of alternative remedy before the Industrial Tribunal. Thereafter, an application was preferred to the conciliation officer and the dispute was referred to the Industrial Tribunal. After filing of the written statement by the parties and considering the preliminary issues of the validity of inquiry, it was found that the inquiry is not proper and legal, therefore it is vitiated and the petitioners were afforded opportunity to prove the charges on merit. But even thereafter, the charges could not be proved before the tribunal. Therefore, by means of the impugned award, the opposite party number 1 has been directed to be reinstated with all consequential benefits. Hence, the present writ petition has been filed challenging the same. The order dated 3/8/2016, by means of which the inquiry held by the petitioners was held to be vitiated, has not been challenged. Therefore, the inquiry held by the petitioners cannot be looked into. The petitioners also could not prove the charges on merit before the tribunal. Perusal of the pleadings in the writ petition and the arguments advanced before this court, it is apparent that the inquiry before the tribunal, in which also the charges could not be proved, has not been challenged. The impugned award has been challenged mainly on the ground that the opposite party number 1 is not entitled for back wages on the principles of no work, no pay. The charges levelled against the opposite party number 1 were levelled in regard to the operation of the bus on Delhi to Sonauli route on different dates. The first charge was in regard to 4/10/2003. The charges were to the effect that the total number of passengers and the amount has not been entered in words and the stamp has not been put on Khalilabad and Haraiya checkpost. The income is very less than the target. A charge has also been levelled that there is difference in color of stamp, as it is dark in middle and light in the side. The similar charges have been labelled for different dates, that is 14/10/2003, 3/12/2003, 28/9/2003, 7/10/2003, 22/11/2003, 30/10/2003, and 22/10/2003. The petitioners have failed to prove the charges in domestic inquiry as well as before the tribunal on opportunity given by the tribunal to prove the charges on merit. It could also not be disclosed as to what was the target of income which could not be achieved. The petitioners also could not produce any evidence or rule to show that putting of stamp on the check post was necessary. A plea was taken by the opposite party number 1 was that when the bus used to pass from the Haraiya and Khalilabad check post, the check post used to close due to late night, and to avoid the jam on main highway, the employees of the check post used to allow the vehicles to pass without checking stop.